Good morning, Mrs. James.
Good morning.
Now, in a moment or two, Sapna will invite you to take the oath.
Yes.
But let me describe the arrangements for you.
Thank you.
You are talking to those in front of you, obviously. They are members of the public, participants and co-participants.
Yes.
To your left, there are lawyers, amongst them Miss Fraser Buckland, who will be asking you the questions. And at the back of the room, there are, on occasions, members and representatives of the press.
Thank you.
But you have a bigger audience beyond this room. That is those who are watching remotely, either on live stream or by YouTube.
Right.
Now, Sapna.
Please state your full name.
Anita Mary James.
Take the book in your raised hand and repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth. Thank you.
Mrs. James, I just want to start with a brief overview of your career, so we have the picture of what you did.
Yes.
You were in practice as a barrister until 1981.
Correct.
And then joined the Government Legal Service.
Yes.
And you worked within the Department of Health and Social Security.
Yes.
And when the DHSS split into the Department of Health and the Department of Social Security, it's right, isn't it, that the lawyers working within the DHSS were formally employed by the Department of Social Security.
Correct.
But continued to act for the Department of Health.
Yes.
You remained working on Department of Health matters until May 1996.
Yes.
When you transferred to the Department of the Environment.
Yes.
And then March 1999, you returned to the DSS, and therefore the Department of Health as well, as Head of Civil Litigation.
That's correct.
And in that role, you were responsible for all types of litigation across both the DSS and the Department of Health.
All sorts of civil litigation, yes.
And you stayed in that role until December 2005, and in January 2006, you became Head of Employment.
That's correct.
Until your retirement in May 2007.
Yes.
Before we address specific issues of documents and the Hepatitis C litigation, can you start by explaining how government lawyers work within a government department? How, firstly, were your team at this time separate to what we now know as the Treasury solicitors?
They were, yes. We were directly employed by the Department of Social Security.
And what difference do you think that made to how you functioned as a lawyer within the department?
Not being part of the Treasury solicitor, do you mean?
Yes.
It didn't make a lot of difference because we had a lot of contact with the Treasury solicitor, and we had joint meetings of all government civil litigators, that sort of thing.
And in terms of physical space, were the lawyers in the same office space as the Department of Health officials, or were you in a different building?
No, we worked in New Court in Carey Street.
So you were separate to them?
Yes, we were with a few other government departments, Inland Revenue and Monopolies and Mergers, that sort of thing.
So can you help us then with how you interacted on a day-to-day basis with officials in the Department of Health? How often did you meet with them? How did these interactions come about?
We met with them whenever they needed legal advice.
So if there was some litigation started, where would the writs, the words used to be, where would the writs come? Would they come to you as the solicitors, or would they come to the department?
They would come to us. We were in the White Book, the Civil Litigators Bible, you might say, as the Office for Service.
And once a writ arrived, how did you set things up with the policy officials who might know a whole lot more about the issues, perhaps, than you as a solicitor, as a barrister?
I would get in touch with whoever needed, or the lawyer acting would get in touch with whoever needed to be contacted to take the matter forward.
as a lawyer within the DHSS and within the DSS,
yes,
was your role confined to advising officials on litigation, or were you also involved in advising on the legality of policy decisions that they were contemplating?
rarely the latter.
So primarily it was interaction if there was litigation.
Yes.
And how much interaction did you have with ministers?
Personally, not a lot.
So can you just help us with how interactions through the department worked? You might receive a writ, you engage with a policy official. What then?
Well, principally we're talking about judicial review, in which case we would get in touch with the policy officials. And if it was an incredibly serious matter, which of course judicial review nearly always is, then Minister's office would be informed and ministers consulted as to the way forward.
And when ministers were consulted, who would do that consultation, generally?
It would be the policy lawyers via the private office of the minister.
And again, just looking at matters from an overarching perspective,
yes,
in terms of documents,
yes,
what types of documents were held by the lawyers in the department as opposed to the policy team?
the documents held by the lawyers, certainly the lawyers in my section in civil litigation, would be solely in relation to the litigation.
And so when a writ arrived and you needed presumably information and documentation,
Yes,
generally how would the team go about obtaining the information they needed to respond to the litigation?
well, they go to the policy lawyers and then to the policy administrators.
And when they went to those policy lawyers and policy administrators, would the lawyers be provided with copies of documents or would they be provided with originals?
We rarely had originals
Why was that?
because it's not necessarily very safe to let originals out of off a file, from a file. So it would be better to keep them sort of on the registered file and we would have copies.
And very practically, who would go and get those documents? Physically obtain them? Would it be one of your team who would go to the department and sift them from the registered files?
Sometimes.
Or would it be the officials who would do it?
Sometimes.
So
Combination of both, if you like.
And we will look at some documents that discuss the issue of a disclosure statement for the court.
Yes.
For those listening who aren't lawyers and aren't familiar with such things, can you just explain briefly what a disclosure statement is?
It's a list, basically, of documents that are relevant to the litigation. And the lawyers for the claimants would look at that list and decide what they wanted, whether they were indeed relevant or whether there's more to be had.
And the disclosure statement would have to be signed by a lawyer, wouldn't it?
Yes.
Confirming that, I'm paraphrasing, reasonable searches had been done,
Yes.
and these were the documents that you considered were the ones that should be disclosed.
Yes.
And so would that be a senior lawyer?
Not
employed?
necessarily.
How would it be decided who would sign the disclosure statement?
It would be the lawyer involved in the case. I used to allocate the cases according to a person's ability, according to how I saw their career developing, and of course to give them some interest in the work, because it wasn't always the case that junior lawyers found themselves dealing with interesting cases. So I tried to balance it, but if there were serious matters involving ministers, challenge to policy decisions at the highest level, then I would probably deal with it myself, or the lawyers on the next rung down, the grade 6s, would deal with it.
You said a moment ago that within your department you would generally have copies of documents
Yes.
relating to the litigation.
Yes.
Again, just generally, whose responsibility would it be for dealing with those documents once litigation had come to an end?
They would be, the file they were on would be closed. They'd be kept in my office for 6 months or so, and then they would go to remote storage with a recommended destruction date or review date.
And in various of the exhibits to your statement, there are references to documents going to Hayward stores.
Yes.
And to some documents to going to D.H. Nelson.
Yes.
Are they both remote storage points?
Yes, they're very akin to a large warehouse. Hayward Stores was near Manchester and at a confluence of a number of motorways. So it was where there was space for a large amount of storage, and they were kept on shelves in boxes, and if we wanted to have them back, then we could get them back within the time frame allocated to them.
And do you know why some documents went to Nelson and some documents went to Hayward? What was the rationale between those two locations?
I think that must be historical. The Hayward stores would have been DHSS originally, I suppose, and then DSS, whereas Nelson was Department of Health.
And you said a moment ago that you could retrieve them,
yes,
as long as they were within the time frame,
yes,
for second review and destruction.
Mm-hmm.
Who decided what the dates would be for that second review and the destruction date?
If the file was my responsibility, I would decide myself how long to allocate a destruction date for.
And did you have guidance or a general rule of thumb in the department of what that date should be?
I never saw any written guidance. I learnt all about it from the first line manager I had as long ago as 1981. He explained everything to me, and I adopted what he told me.
And what was that? What was your general rule with destruction of documents on putting that date on?
If they were particularly important, contained policy review, or even very, very occasionally had historical importance, I'd put something like 25 years on for 20 years, 25 years for review. And then, again, destruction would be decided upon after that. So I suppose now that most of the files I sent have gone.
Let's move on to some more of the specifics in relation to the hepatitis C litigation.
Thank you.
The team you were working in 1995 were involved in the hepatitis C litigation.
Yes.
And your involvement arose in February 1995.
Yes.
Just as a preliminary, before we go to the first document, when you became involved in that,
yes,
were you the primary solicitor dealing with the matter, or who was heading it up?
I seem to recall we were all in it. So I was the junior lawyer. Then there would be my line manager, Charles Blake. We copied in the then grade 4, Peter Nielsen sometimes. And then Peter Thompson, the grade 2, the solicitor to the departments. He was very, very interested in the case. So he took an interest in the overall things.
Could we turn to WITN 5426004, please? We have here a memo from Roger Schofield to Charles Blake,
yes,
who I think you've just said was your team leader, line manager.
Team leader, line manager, whatever you like to call him. Yeah, he was my boss.
And then we have the section headed summary. I'm just going to read some parts of this memo out and then ask you about it.
Okay, thank you.
This paper seeks to set in motion a process of discovery of relevant papers and records in order to ascertain whether the Department, the National Blood Authority, NBA, or any other party has acted negligently as regards the safety of the blood supply and in caring for the interests of patients who may have been inadvertently infected with hepatitis C virus through blood or blood products. It seeks advice on the general vulnerability of the parties concerned to such claims and specific advice on a number of issues arising from the hepatitis C look-back exercise.
Yes.
Then it sets out some background to the issues, including that there'd been questions in Parliament about the handling of hepatitis C testing. Then we go over the page and we pick up at the heading possible past negligence. Having got the major part of the response package moving, we now need to address the issue of negligence. Writs have been served against individual regional transfusion centres for negligence in supplying infected blood. The cases considered occurred during the window period, 1989 to 1991, i.e. after the first tests for hepatitis C were available and before all donations were routinely tested in this country. We've asked the MBA for full details. It's understood they haven't yet entered any detailed defence. However, the case would be as follows. 1. Screening was introduced in September 1991. The first anti-hepatitis C tests were reported in the literature in March 1989, but did not become available until later that year. 2. These first tests had too large a number of false positive and false negative results, and no satisfactory confirmatory tests were available. Expert advice was that these tests should not be introduced because of these deficiencies. 3. The Department of Health funded several trials of the first and second generation anti-hepatitis C test kits. Screening was introduced in late summer 1991, following advice from the ACVSB. Pausing there, when you became involved in this matter,
yes,
did you probe those 3 points at all as to whether they were a defence, whether they stood up to testing?
No.
Why was that?
I can't say at this point in time. I think I'd saw the minute, and the next stage was to sort of go on and perhaps see counsel.
The document then carries on at paragraph 13. A case might be brought which alleges failure to mount a look-back exercise, so it's picking up the next issue, alleges a failure to mount a look-back exercise once tests were available and infected donors could be identified and recipients who'd been exposed to infection might be traced. And then the defence which we've given publicly to this is that, and there's 4 points.
Yes.
Dealing with why a look-back wasn't pursued. Again, did you probe any of that at this stage?
I don't believe so, no.
Thinking about your role as the solicitor, one of the solicitors in the department,
yes,
and this context of whether you probed information you were being given, as the solicitor in the department, would that have been your role, to test and probe what you were being told?
I think as time went on it would have been, but I don't believe I did so here.
And then can we pick up the next heading on the next page, discovery of papers?
Yes.
Paragraph 21. I've asked Tom Kelly and Dr. Raymond to draw up a sequence of events and to assemble the key papers, including records of the ACVSB and the MSBT. I understand that Dr. Harold Gunson did quite a lot of work on this before retiring from the NBA, and I've asked Dr. Robinson to get hold of this information for us. And then paragraph 24 at the end of the document, end of the page, in the middle of that paragraph, before going too far ahead with the discovery process, it might be useful if we had a quick meeting to ensure we're on the right lines and targeting the right issues. Can you help us with what your understanding was of what was meant by being on the right lines with discovery? What was the particular concern here?
I can't remember, I'm very sorry.
You then became very specifically involved in relation
Yes.
to some UK HCDO papers.
Yes.
If we turn that up, WITN 5426006. This is a memo from Dr. Raymond to Mr. Blake.
Yes.
And it's headed HIV haemophilia litigation. And we see in paragraph 5, what's happened is, I'm just going to paraphrase the first 4 paragraphs, Dr. Raymond was enclosing a letter from Dr. Colvin about whether he should disclose the UK HCDO minutes to Professor Hardestry for the Irish HIV litigation. And paragraph 5, Dr. Raymond says, I'd be grateful for advice on how to reply to the letter. Among the papers will be a significant amount of discussion regarding non-A, non-B hepatitis C, which we might not wish to have in the public domain at the present time or in the near future.
Yes.
You were asked to reply, and if we turn to your reply, and then I'm going to ask you about it.
Okay.
WITN 5426008, please. In the middle of paragraph 2, you note, I think that's referring to Dr. Raymond,
Yes.
do not want the papers to be disclosed. I think your strongest point is the confidentiality one. It's one which was accepted by the court in the context of the haemophilia litigation, but it has to be said that the point is somewhat weakened by the fact the information was disclosed to the court, albeit on undertakings. In view of what you say, I think there's little choice but to decline to disclose and fight it out in court.
Yes.
Before you provided this reply to Dr. Raymond, had you seen the papers that he was discussing?
I don't believe so, no.
Why did you think that the papers shouldn't be disclosed and it should be fought out in court?
I'm really sorry, but I just can't remember at this distance in time.
Do you have any recollection of any discussions about whether these papers should be provided?
No.
You were also tasked with addressing the assessment of the department's potential liability in relation to hepatitis C. And on the 31st of March, you asked Dr. Raymond to provide you with a chronology of events and the relevant supporting documents.
Yes.
I'm not going to go to it, but for the transcript, the reference is WITN 5426011. In asking Dr. Raymond to produce a chronology and provide you with the relevant documents, would that have been your usual approach in these situations when you were asked to advise?
Yes.
Now, Dr. Raymond was obviously a doctor rather than a lawyer.
Quite.
What guidance did you give him about how to decide if papers were relevant or not?
I left it to his discretion.
Did you give him any steer or indication of what he should be looking for?
I can't remember doing so, no.
You then received a response from Dr. Raymond simply copying an earlier note that he'd written about hepatitis C and saying that if more work was needed, he would require authorisation.
Yes.
And we have Mr. Schofield then giving that authorisation.
Yes.
If we can turn to that, at WITN 5426014. And we see at paragraph 3, we agreed that it would be helpful if Sol B4, CAOPU and yourself, that's Dr. Raymond, agreed the rules for discovering relevant papers.
Yes.
It seems to me that, as in many other cases, the law of diminishing returns applies. It's more important to spend a few days pulling out the most important papers than to embark upon a task which may last many weeks and only add limited additional material. there is clearly a real urgency for us to come up with some advice on the strength of our overall position. Was that your advice as well, that there should be a few days pulling out the most important papers rather than a full trawl of everything?
No.
I'm sure I'll be corrected if I'm wrong, but there isn't a document challenging that position from you. Mm-hmm. Did you challenge it?
I don't believe so, no.
Can you help us with why not?
I think I trusted Mr. Schofield's judgment.
But as the solicitor, as the lawyer in charge of the litigation,
yes,
what was your role if Mr. Schofield was going on the wrong track?
If he'd gone on the wrong track, I would have told him so.
So from that, do you then consider that he wasn't going on the wrong track here? That there's not a challenge?
I don't believe so, no.
As matters progressed,
yes,
and as the litigation was pursued,
yes,
was that position on documents ever revisited? That actually there needed to be a full trawl rather than this initial quick look?
I can't remember, I'm sorry.
If we can turn to page 3.
Can I just be clear what the legal position was at this time? Generally speaking, in litigation, you'd expect a full trawl, would you not?
Is that a question to me,
It
sir?
is.
Yes, sir, absolutely. If one was signing the disclosure statement, the civil rules, as I'm sure you're very familiar with, were that a full trawl was required.
Yes. So this was a proposal by Mr. Schofield to do rather less than the law required, and nobody appears to have objected to it.
So that appears to be the position, and as we go through the documentation through the years, and again I'm sure I'll be corrected if I'm wrong, there doesn't appear to have been a decision to re-look and do a reconsideration of whether everything has been looked at.
Yes, thank you.
Can we pick up at paragraph 14 of the document? In looking at our papers, therefore, it would seem to me that the first priority should be looking at the papers for and records of the meetings of the ACVSB, including any special subcommittees, etc., and including any official groups within the blood service. We should be looking for papers which either relate to possible claims for negligence, judged from the perspective of the recipient and not from our own, and also for papers which, if exposed in public, might be used to ridicule the way in which the service is managed or decisions on safety are taken. Again, can you assist us in relation to what your advice on this point was as to what documents should be looked at as a first priority?
No.
And can you help us with what you understood Mr. Schofield to be talking about when he said papers which might be used to ridicule the way in which the service is managed?
I can't say what he was thinking about.
Was there any discussion at the time about what he meant?
I can't remember there being any.
That's the document's element, as it were. I just want to go back a page to paragraph 10 to pick up on Mr. Schofield's more substantive points.
Yes.
Paragraph 10. As I understand it, our worry is as much about what might come out in the course of a court action as the actual verdict, and I suggest therefore that any examination of documents should be addressed as much to their presentational significance as to the case for negligence itself. There is no doubt in my mind that there are a number of documents which would show that the process of deciding whether or not to test took account of cost and the impact on the blood supply and stocks, etc. There are also the ethical problems over what you tell those who are found to be positive. But looking at all of this from the point of view of the recipient, who's now in end-stage liver failure, or perhaps the father of a child who was infected in this way, one can see that these explanations and defences would seem pretty irrelevant compared to the fact that tests could have been carried out and were not. Another whole area of vulnerability is the action by other countries in introducing Hep C tests. Whilst it would be understandable that one or two countries might jump the gun and go ahead before the tests were really of any great value, we're actually asked to believe that pretty well every major blood transfusion service in the world, apart from the UK, decided to go ahead with such useless tests a year or more earlier than we did. On the face of it, this sounds as if either they were all a bunch of clowns or we must have had particularly good reasons for hanging back. Again, we know how long it takes to carry these things through committees and to undertake additional tests and to ensure that every RTC is at the same stage as the others so that the procedure can be introduced on a UK-wide basis. But when we put all these things together, the story sounds as if there was an inordinate administrative or bureaucratic delay. I'm drawing out these uncomfortable areas because if any one of them can be used to establish a case to be answered, then we may be dragged all the way to the court. It might be suggested at a later stage that that was a particularly insightful view.
Yes.
Was it a view that you shared?
I don't think I had a view, really. I can't remember expressing a view on what had happened because I didn't particularly, at that point, understand the science.
Was that view something you discussed with Mr. Blake as your line manager?
No.
Mr. Blake attended a meeting with Gerald Malone, the Minister of State, on the 7th of June 1995. Yes. It's not a meeting that you attended,
no.
But we have the minute of the meeting, and for the transcript, it is DHSC 303552_001. We don't need to go to it, but the minute doesn't include any reference to the what one might call human aspect of Mr. Schofield's view.
No.
Did Mr. Blake talk to you about the meeting with the Minister at all? And whether there was a discussion about those points?
No.
In light of the points made by Mr. Schofield, I've been asked to ask you whether you think, with the benefit of hindsight, at that very early stage, you should have pressed harder for a settlement or pressed for the department not to defend the claims from the outset.
Me personally?
Yes. As a lawyer advising, whether you should have been pressing harder at a very early stage.
I think if I had felt the need to press further at that stage, then I would have gone up the office to Charles Blake and then to Peter Thompson, and they would have had to take the matter forward because it would have had implications for ministers. And it wouldn't have been for me at that level, at that stage, to make that sort of decision or assist ministers in making such a decision.
And did you take it up, the office? No. Did you press that up the line?
No.
Returning to the question of documents, there were several memos sent to and from Dr. Raymond about the priority to be given to the work on obtaining documents. And following Mr. Schofield's memo that we've just looked at, which also set out the work to be done, Dr. Raymond responded. WITN 5426015, please. That wasn't, sorry, 016. Oh, sorry, just a moment, sir. I've got an erroneous reference. 016. Apologies, my handwriting. WITN 5426016. Thank you. Paragraphs 2 and 3, Dr. Raymond sets out his views on the litigation. I believe a fundamental difference exists between legal vulnerability for the period autumn 1989 to September 1991, the so-called window period, where some very poor tests were available, and the ACVSB advised that HCV screening should not be introduced in the UK. I will not rehearse all the various arguments, but suffice to say that donor interests, availability of blood, public perception, etc. are all relevant in the UK, and we're aware that in other countries these may well have been disregarded for political reasons. The situation with the haemophiliacs is entirely different, since there was no hepatitis C available prior to late 1985, when all the blood products, both for haemophilia A and haemophilia B, were being heat treated. The argument about hepatitis in respect of haemophilia were presented in the HIV haemophilia litigation. The impression I've obtained, though I stress I'm not a lawyer, is that legal aid might be extremely difficult to obtain if the plaintiffs had to show the Legal Aid Board the expert witness reports in respect of hepatitis that were submitted for the HIV haemophilia litigation. Did you ever have a discussion, I'm asked to ask you, did you have a discussion with Dr. Raymond about the Legal Aid Board and whether there should be any interactions between you and the Legal Aid Board?
No.
The document then sets out the task, that the task involved a lot of work. And if we go over the page, paragraph 7, Dr. Raymond says this: I would be loath to go down this avenue of revisiting work from ACVSB and MSBT without a formal instruction from Dr. Metters.
Yes.
In response, Dr. Metters then instructed Dr. Raymond that he was to undertake the work, and we then have a document from Dr. Raymond to you, which I'm going to ask you about.
Thank you.
WITN 5426018, please. Paragraphs 2 and 3. I've gone through all my files and am now partway through the official files held by Mr. Burridge. This first phase of the discovery is limited to the period 1989 to 1991, the time between announcement of hepatitis C and the introduction of a screening test in the UK. So far I've listed approximately 600 documents, and I hope to have completed this part of the exercise by the end of next week or early the following week. In the documents we've looked at, Mrs. James,
yes,
we can see Dr. Raymond asking for authorisation and then asking for direct instruction to do the work.
Yes.
Did you have any concerns at the time about Dr. Raymond appearing to be somewhat reluctant to do the document search?
No. Dr. Raymond was a bit of a law unto himself in the sense that he wasn't a great respecter of lawyers, but then, you know, that goes with the territory. And no, I think the simple answer is no.
And with the benefit of hindsight, would you have any concerns about him undertaking this exercise?
Well, hindsight's a wonderful thing, and with the benefit of hindsight, it would have been better if the task had been completed by a lawyer.
And why particularly do you say that?
Because a better assessment would have been made, perhaps, about the documents. The relevance of the documents, that is.
And when we think about relevance, and if a lawyer hasn't undertaken a document search, sometimes one can receive bundles and bundles and bundles of papers,
yes,
largely irrelevant, and in there's a nugget of relevance.
Of course.
Or one can receive very few documents, and one is left wondering where all the relevant documents are.
Yes.
With Dr. Raymond, which camp do you think his document search fell in?
The former.
The
former.
The too much that was irrelevant?
Yes.
Do you think there was a risk that he might also have missed relevant documents and not provided them to you?
Probably not.
Why do you say that with such confidence?
Because I think he might have known what was relevant and what wasn't. He'd been involved in a previous discovery exercise. So he had a pretty good idea, I think.
We saw in that note that's on the screen, apologies, in an earlier memo that we looked at, that Dr. Raymond expressed his own view of what the prospects were of the litigation. Yes. Did you have any concerns that that view might affect how he considered documents to be relevant or not?
No, I didn't have any concerns.
I want to move on then to the next memo from Dr. Raymond to you about the documents. DHSC 02 3022 _ 002. From Dr. Raymond to you, dated the 7th of June 1995. I'm sending you by hand the list of documents I've discovered in relation to the period 1989 to 1991. I've gone through all my files and have gone through the files made available to me by Mr. Burridge, GEB Vols 1 to 14. Unfortunately, Volume 4, for part of 1989, has apparently been destroyed. Mr. Burridge has asked for the individuals responsible to write to him formally confirming this. First of all, during the inquiry, the initials GEB have had different acronyms attached to it. Do you know what the GEB stood for?
Well, I think the B must be blood, but I don't know what GE is.
Did you have any concerns when you received this memo that a file was missing?
Well, I would have had concerns, yes.
And was there anything that you then did about that at this stage, before we get to the audit report?
No.
Why was that?
I can't remember, I'm sorry.
We see here that Mr. Burridge has asked for the individuals responsible to write to him formally. So it seems reasonably apparent, something we'll come back to, that it wasn't Mr. Burridge who destroyed the documents.
No, it wasn't.
And indeed, again, we have a witness statement from Mr. Burridge available to us.
Yes.
In fact, it's worth us just looking at a section of it, and I believe it was provided to you before today.
Yes, it was. Thank you.
WITN 7149001, please. Paragraph 10.1, so page 16. We see there that Mr. Burridge has been asked to comment on this memo, and then we carry on down the page. 10 point, yeah, thank you. Prior to reviewing the documents provided to me by the inquiry, I had little recollection of these events. The memo records that I'd provided volumes 1 to 14 of the GEB1 series to Dr. Raymond to the extent that they'd been retained by the Department of Health. He then discusses the docket, which this inquiry's heard evidence on before, and then we pick up in 10.4. As I set out above, I do not now recall writing to any individuals who I believed was responsible for destruction of Volume 4 in error, and nor do I recall their identity. As mentioned, the letters I am said to have sent have not been located, despite extensive searches. So just one point in relation to that. Were you made aware of that at the time, that Mr. Burridge was due to write to individuals? He had written to individuals. What did you know about Mr. Burridge's actions or Dr. Raymond's actions in trying to find who had destroyed, who'd authorised for destruction GEB Volume 4?
Well, I knew they were looking, but not exactly what had been done.
You then provided an update to Mr. Holloburn. It's setting out that you had received all these files from Dr. Raymond, and that you needed to look at them. You also highlighted in that you had some papers which take the form of submissions to ministers.
Yes.
Where would you have obtained those documents from?
Thinking about it, I think they must have been on the files in the solicitor's office.
And how would they have come to be on the solicitor's office files?
Because they would have been copied in, the submissions to ministers, copied into the relevant lawyers advising ministers.
So at this stage you had the files from Dr. Raymond.
Yes.
And you had the submissions to ministers, but you knew that one file was missing.
Yes.
What did you do at that stage about trying to reconstruct the contents of that file from other papers?
I don't remember doing anything.
And again, why was that? Why was that not a gap that was plugged at that stage?
I'm afraid at this stage I can't say.
If we then turn up WITN 5426019. We have a list of the documents that Dr. Raymond had compiled.
Yes.
And just looking through it, there isn't anything here that picks up any of the HIV litigation documents. I think you've had this list provided to you before.
Yes.
And again, I'm sure others behind me will correct me if I'm wrong. So there's not the claim form or the expert reports or anything of that sort from the HIV litigation?
No.
Is that right?
Yeah. Yes.
So at this point, again, the documents you were being provided with from Dr. Raymond, you would be aware were missing some key parts?
Yes.
When Dr. Raymond sent you we can take that down, thank you. When Dr. Raymond sent you the 14 files of documents that he described,
yes.
Do you recall if they were complete documents or if they were just extracts?
I just can't remember.
If we then pick up in June 1995, Dr. Raymond then does provide you with some of the papers from the HIV haemophilia litigation at WITN 5426022. We can see he's providing you by hand further discovery. These all relate to HCV and haemophilia, although they don't have any direct bearing on blood transfusion between 1989 and 1991. It's worth noting that they were available to DH during the relevant time, and they've come, on this occasion, from the HIV haemophilia litigation. And he then says this: as agreed, I do not intend to go through the full discovery list which we prepared at that time, but have restricted myself to papers surrounding that litigation. I list below the papers I'm sending you. If any copy recipients wish to see any particular papers, will they contact me? And then relevant extracts from the main statement of claim, counsel's advice on liability, relevant extracts of the draft defence, and expert witness reports. We can see that Dr. Raymond has said he's not gone through the full discovery list that was prepared for the HIV litigation.
Yes.
Did you question that at any point about why he hadn't?
No.
With the benefit of hindsight, do you think that discovery list from the HIV litigation is something that should have been gone through in full?
Yes.
We can also see here this reference to relevant extracts.
Yes.
It might be suggested that Dr. Raymond was filleting a whole raft of files and taking things out,
Yes.
extracting things that he thought were relevant. Did you at any point ask simply for all the files to be sent over?
I don't recall doing so, no.
And why not?
I just can't remember what was going through my mind at the time. I know this is sounding rather lame, but I just can't remember very much at all about 1995, 96.
Do you recall any consideration or discussion about whether one of your junior solicitors or perhaps a paralegal should be sent across to the department, comb through and bring all the files back?
We had no paralegals, and I was the junior solicitor. So I think the simple answer to that question is no.
In light of the possible gaps in the papers,
Yes.
were you satisfied at the time that you were providing all the relevant documentation to counsel when advice was being sought?
I think so, yes.
What gave you that confidence?
I just can't remember.
You'd also been asked by Mr. Thompson, the
Yes.
most senior solicitor in the department.
Indeed.
The sort of grade two.
Grade 2, that's correct.
He'd asked that advice was sought from counsel, from the barrister, about whether blood fell within the Consumer Protection Act 1987. You sought that advice,
Yes.
and on the 12th of July 1995, the advice was that it was a product within the Act.
Yes.
That advice was sent to Dr. Raymond for his views, and he disagreed
Yes.
with the barrister's view.
Absolutely.
Was it usual for counsel's advice to be sent to the department for their view?
You mean transmitted between the solicitor's office and the...
Yes, exactly. Would it be normal for you to send it on to the department?
Not always, because it might be couched in language that maybe for want of a better word, the lay client wouldn't understand. So it needed a bit of translation, if you like, but it would always be available to the client department because essentially it was advice to them.
And Dr. Raymond sets out his views at quite some length as to why counsel was wrong.
Yes.
Was it usual for an official, someone in the department, to write at such length, arguing against advice that had been received?
Legal advice was frequently challenged.
Including by people within the department?
Yes.
So there was nothing particularly unusual in Dr. Raymond's response?
No, I mean, everyone from Secretaries of State downwards would challenge.
And then in September 1995, you had a conference with counsel and Dr. Raymond as well.
Yes.
About his views.
Yes.
Again, was that a sort of normal thing for the team to arrange a conference if somebody in the department was disagreeing with the advice?
Well, yes, because they can then... He didn't raise an objection in the first place when he was there. So the point in taking him along to the conference was so that he could put his views, and those views could be tested by those present at the conference.
I want to return to some further documents and the question of where documents went.
Yes.
WITN 5426039, please. It's a memo from Leonard Levy to Miss Towner and to yourself.
Yes.
And it seeks advice about a McFarlane Trust payment and the payment of legal costs.
Yes.
And then at the end of paragraph 2, it says an exception was that £2,000 for persons not infected with HIV but at risk, e.g. wives, was only available to those who were pursuing litigation, i.e. had served a writ before the 13th of December 1990. And then this. Unfortunately, our policy files giving the reason for the distinction appear to have been destroyed. I would therefore be grateful for any light you could shed on the reason that the £2,000 payment was not made available to non-litigants. Then I just want to look at another document and then ask you about it.
Yes.
And that is WITN 5426040. It's a reply from Ms Towner to Mr Levy. Paragraph 2, I'm not really happy that this issue has yet been as fully researched as might be appropriate, despite the difficulties that are apparently involved. For instance, there are some papers in LIE 16 volume 15 which discuss category G cases and changes to the Scottish scheme in this respect that are of interest, and there may well be more on earlier files or elsewhere, and I would have liked a summary of the circumstances in which legal expenses are being paid. And are you sure that earlier files in that series have been destroyed? To my reading, the dockets only indicate that they've been sent to DRO for destruction after 25 years, which would not, of course, be yet. Perhaps you'd let me know if they have in fact already been destroyed. We may need to think of reconstructing papers, e.g. from what Dr. Raymond and other hold. So there are two further memories about the possible destruction of important policy files.
Yes.
Did that raise any concerns for you at the time?
I don't remember raising any concerns, no.
We obviously see in Ms Towner's reply that she
Yes.
queries whether or not the files had in fact been destroyed or not.
Yes.
You were aware that infection from blood and blood products was still very much a live issue. Did you do anything at this stage to ascertain whether or not policy files had in fact been destroyed?
No, not policy files, no.
You'd also been told that GEB4 had been destroyed.
Yes.
What steps did you take to ensure that the policy team didn't destroy any other files at this point?
I don't believe I took any steps, and obviously we should have insisted that files were better looked after.
And I just want to put up a paragraph in your witness statement because you address this
Yes.
very, very clearly there. WITN 5426001. You address later files as well, but this is a helpful summary of, I think, your position in relation to documents generally. Paragraph 6.32, so page 100. Now, there's a further matter which I should address here, which I stress is only apparent to me now on reviewing all these papers. When the fact that files were missing emerged in early 2000, so discussing some later files,
Yes.
I'm quite sure I'd entirely forgotten that there'd been a minute nearly 5 years earlier from Dr. Raymond that had mentioned the destruction of the first of those folders. Looking at it now, I can see from the audit report that some of the volumes were destroyed after June 1995. That is to say, after Mr. Burridge, Dr. Raymond and I had been alerted to the destruction of Volume 4. That's why I've made clear, at paragraph 614, that between us we should have ensured that a clear message was delivered that such files should obviously be retained, marked for lengthier retention. While I cannot now say whether I did say anything to that effect at the time, I very much regret that between us we did not act so as to make sure that other files which had been marked for destruction were not in fact destroyed.
Yes.
When you say there that you, Mr. Burridge, Dr. Raymond and you should have ensured a clear message was delivered, very practically, what are you thinking should have been done?
What should have been done was to make sure that anybody involved in the management of those files understood that they were important. And even if they didn't know the contents of the files themselves, that they were important and that they should be kept and have a long, first of all, review date.
And would that have been done by a memo round the department, or?
Well, it might have been done by a memo, or actually, I think it would have been important to put it in writing, yes, but reinforce it by going down and seeing people and talking to them about the importance of documents that might be involved in litigation in the future when they perhaps had moved on to other things.
And in your role as solicitor, as the lawyer in the department, who may at some future stage be signing that disclosure statement.
Yes.
Was that your role to go and bang heads together, as it were, in the policy department, or was it for you? Was it for Mr. Burridge to deal with, or Dr. Raymond? Whose responsibility was it?
Well, I think a reasonably senior person should have done it.
And who?
So Mr. Burridge, as I recall, was a higher executive officer, very capable person. But Dr. Raymond as a doctor and me as a senior lawyer would have perhaps carried a little more weight, no disrespect to him, but that would have been the case.
Throughout this time frame of your first stage in the DHSS, as it were, there were a number of memos and a submission to the Minister about whether a compensation scheme, a financial assistance scheme, should be established for those infected with hepatitis C.
Yes.
You've addressed the documents in your witness statement, but what was your involvement in the substantive issue of whether there should be a scheme or not?
That would not have been for me.
Because as a lawyer in the department, it's not your role.
I didn't have any input into policy, unless to say whether it was illegal or unlawful.
At this point in time, you were then due to move departments.
Yes.
And you handed over the matter to a Miss McEwen.
That's correct.
If we could turn up your memo to her, WITN 5426072, please. We can see it's dated the 18th of March 1996.
Yes.
We discussed this matter and you very kindly agreed to take the matter forward. I have to say at the outset that this will involve a lot of work, both from you and from the support staff, and it all may come to nothing, as it might be decided by the Secretary of State to set up a scheme like those he has had in relation to HIV and haemophiliacs and HIV and blood tissue transfers.
Yes.
And then paragraph 3. Our clients are in the Department of Health. It's said by Keith Park that the department has been negligent principally in not providing adequate tests for hepatitis C. Hepatitis C is carried in blood. It was identified relatively late in the history of hepatitis. And then your paragraph continues setting out essentially what your understanding of hepatitis C was.
Yes.
And it largely follows the line to take that the inquiry has seen in a number of contexts.
Yes.
Was this your view from reading the documents, or was it simply what you'd been told was the position?
I think it must have been a combination of both. I seem to remember if I was going to write like this, which I now can't remember writing the minute, but I obviously did. And a lot of it would be in my head, if you like, as a result of what I had seen and what I had read.
And we see in the paragraph that you've highlighted the department's vulnerability, being the period between 1989 and 1991.
Yes.
But we also see at the end your comment, the irony in all this is that seriously ill patients were given life-saving transfusions and haemophiliacs blood products in good faith, but the outcome's been hepatitis C.
Yes.
You said this came from your head and from reading and from talking to people.
Yes.
Had you questioned any of the information you were being given about whether this was right, whether it was accurate, and whether the evidence supported what you were now writing?
Well, I must have understood the parts about hepatitis A, B and C from medical advisors to the Department of Health, and deduced about the department's vulnerability because that was what they had described as the window period. And apart from that, I don't think I questioned it.
If we then turn to WITN 5426073. We have a memo from Ms McEwen to Mr Powell, dated
Yes.
the 20th of March 1996. So just 2 days after you had handed the matter over to her.
Yes.
And she writes this: I understand from Anita James that you handled the HIV haemophilia litigation and that your branch have all the files. We've now received a statement of claim in relation to hepatitis C. We understand it to be based on the re-amended statement of claim of the HIV haemophilia litigation. I'd be very grateful if we could have your papers from that matter as soon as possible. I anticipate they'll have to be retrieved from storage. However, I'd like sight of them before I instruct counsel. 2 days after the handover, Miss McEwen is asking for the HIV litigation
Yes.
files held in the solicitor's department, Sol B3.
Yes.
Was that something you had told her she needed to do when you handed over?
No, I hadn't told her to do it.
Why hadn't those HIV litigation files sitting in Sol been retrieved earlier?
I don't know.
Was it something you had considered and not had time for, or was it something that simply hadn't crossed your mind, do you think?
Oh, I had to find time to do everything. So whether I had considered it, I knew they were there. And I knew that Ronald Powell, for example, unlike Charles Blake's department, were much more assiduous in keeping their files. So I knew they were all there, but I just never thought to look at them.
And then if we turn to 5426077, please. We have another memo from Miss McEwen to Mrs Kerrigan.
Yes.
I've recently taken over the hepatitis C litigation from Mrs Anita James. We have at present one active writ in the High Court, one case in the County Court, and some 11 letters before action. It's come to the notice of Sol B4 that we do not seem to have a policy lawyer. I anticipate you would want someone to be involved and kept informed of the progress of the matter.
Yes.
Why would a policy lawyer be relevant here? Why would one want a policy lawyer?
Because they would have been involved in the evolution of what came to be the policy of the Department of Health.
So what information would they have provided to the litigation lawyers?
They might have provided reasons why certain things were done.
And would they also hold documents that would deal with that sort of thing?
They too would have had registered files, yes.
And would those registered files have been separate to the GEB files that Dr. Raymond had gone through?
Yes, they were exclusively the solicitor's office's papers, if you like.
So we're now in April 1996.
Yes.
Why had no one been approached before this?
Well, I never thought about it, I know. And of course, perhaps it's worth saying that Peter Thompson had overall oversight of those bits of the department.
So you said earlier that you were a reasonably senior lawyer, but you weren't at the top of the hierarchy, obviously.
I was what's called a grade 6, which is the rung below senior civil service.
So would you have had what would now be called supervision on your files with your line manager? Was anyone else looking at what you were doing?
Nobody would have been looking at what I was doing. It would be up to me to take the initiative to ask if I needed help or advice, or if I was getting conflicting advice, how to resolve it.
But there wasn't the regular file review that might now happen?
No.
If we could then turn to WITN 5426083. It's the final topic before we break. And a memo from Miss McEwen to Dr. Raymond. It sets out a request for your urgent assistance. I regret that despite a locksmith breaking into a large number of filing cabinets in the basement at New Court, we've only been able to locate half of the HIV discovery documents. We have files 21 to 43 and 45 onwards. We're therefore missing files 1 to 21 and 44. I believe that the administrators have a copy of the discovery documents. Please could attempts to locate those files begin immediately. If they're located, I'll arrange for Solby 4 to transport the files to New Court. It's obviously vital that we do find these files, as it will save us repeating the discovery process and save many months of work. If we just pause there.
Yes.
Who would have had responsibility for putting the HIV disclosure files somewhere secure at the end of the litigation?
I assume Ronald Powell, but I had no knowledge of any filing cabinets in the basement. I never visited the basement. It was not a nice place to go, but that's no reason for not going there. But it was a very curious place to put these things.
What systems were in place for you to know where old files had gone?
Well, they should have gone to remote storage.
And then if we look at point 2 of the minute, the files that we do have are copy documents. Do we know where the originals are? Do you have any insight for us of where original documents would have been kept?
Original documents belonging to the solicitor's office?
Yes.
Well, they would have been on the registered files.
So these don't appear to have been the registered files that were found. They were simply copies.
I just can't say. I have no knowledge of the basement.
And then we pick up 3 and 4. I regret that I've not managed to locate the reports of Dr. Perry and Dr. Williams that you sent to Solby 4 in June 1995. They're certainly not in our files. I'll continue to search for them, but I would be grateful for copies of the relevant medical reports that you do have. I've not managed to locate copies of the publications that are listed and attached to the statement of claim. Do you have copies of them? And before I ask you about it, I want to just turn to the reply from Dr. Raymond, and then I'll ask. At WITN 5426084. Paragraph 1. I've checked with administrative colleagues and we've identified files 1 to 30. In each case, we have the originals and 1 duplicate set. It's likely that the rest of the files are in a cabinet close by. We're currently trying to find the keys, or alternatively we'll arrange for the lock to be broken. Sol can have the duplicate set of papers. You'll understand our reluctance to pass on the originals in view of previous papers having been mislaid. When the originals are required, we'd ask that these are exchanged for a duplicate set, or alternative duplicates are made at that time. We must ensure at all times that a set is available on at least 2 different DH sites.
Yes.
So files 1 to 30 had been found.
Yes.
But file 44 was still missing. Is that right?
It looks like that, yes.
And then this. I would urge you most strongly to try to locate the reports from Dr. Perry and Dr. Williams, which I sent to Anita James in June 1995. Unfortunately, at that time, I did not make a duplicate set, and I contacted her a few days later to ask for a return of the originals. This was promised but did not happen. I have an earlier draft of the report from Dr. Perry, but I do not have any earlier draft of the paper from Dr. Williams. His report is important, as it's the only report we have from a hepatologist on this matter. It may be that Council still has a copy of the original reports dating back to 1990. In paragraph 5, just before we go to paragraph 5.
Yes.
These reports from Dr. Perry and Dr. Williams, what can you tell us about the apparent loss of those reports?
I can't tell you anything, I'm afraid. I don't know how they came to be mislaid.
Do you recall receiving them from Dr. Raymond?
I don't recall receiving papers from Dr. Raymond, no.
And then paragraph 5, in respect of the publications listed and attached to the main statement of claim, I seem to recall being asked by Sol to send these on to them during the later stages of the litigation, but before the settlement. Sol should therefore still have them. Should therefore still have these. Again, some papers appear to have gone missing.
Yes.
Do you have any recollection about what happened to those papers?
No, I'm sorry, I don't.
And it seems that since then, for the purposes of this inquiry, those reports have been identified. For the purposes of the transcript, I'm just going to give the URNs. WITN 5426085, 086, 087, 088 and 089. Just before we pause for a break,
yes.
During this time, you've said in your statement you were facing significant issues at work.
Yes.
Both in terms of workload and bullying by the manager.
Yes.
Is that right?
Yes.
With the benefit of hindsight, do you think that there are aspects of the disclosure process during this period of time that could have been handled better?
Well, of course, with the benefit of hindsight, yes.
Do you want to elaborate at all on that?
No, I don't think I do, no.
So I'm about to move on to Mrs. James' time at the Department of the Environment and then her return to the department, the DSS. So I wonder if now's a good time to take a break.
Yes, it is. We'll take a break until 10 to 12. Now, this is the first break. You're a lawyer. You will understand that during any break, since you are under oath, you must not discuss the evidence you have given, nor any evidence which you think you may yet be asked to give with anyone, whoever that anyone is. But you can talk about anything else you like.
No, not at the moment, and I completely understand what you have said.
10 to 12.
Thank you.